Last will and testament, and living will. These two things sound similar, but they have wholly different functions. When you think of a will, most people think of the last will and testament. A last will and testament has many advantages. You can outline your final wishes for your personal property, real property, money, and other assets. If you have minor children, you can choose a trusted adult or family member to be their guardian. You can also create trusts to support your children after you have passed. In your last will, you can outline who your heirs are or disinherit those you do not want to gift anything to. The last will is easily changed and is a good way to leave instructions for after your passing. You will pick an executor to distribute your assets and honor your wishes. There are also disadvantages to a last will. It can be challenged in court. Your executor will have to go through the slow and expensive probate process, and your last will cannot address life insurance or retirement accounts. The last will and testament is different from a living will. A living will is a legal document that allows you to express your wishes to doctors should you become physically or mentally incapacitated. It is a part of your advance directives, the instructions you put in place while you are alive to make decisions and designate decision makers for your care. A living will outlines life-prolonging treatments and the treatment plan you wish to be administered if you are unconscious or otherwise unable to make decisions in the moment. Living wills are executed with another advance directive known as the healthcare power of attorney, which gives someone authority to make healthcare decisions on your behalf in the event you become incapacitated. That person is called your healthcare attorney in fact. You can even customize your living will and decide what events may trigger it, the priority of it, and what kind of decisions your attorney in fact can make. A living will does not go into effect unless you are incapacitated, and even then, usually a doctor's certification is needed before the living will becomes effective. For example, if you have a stroke but are not otherwise incapacitated, a living will does not have any effect. Think of it like this. The living will and healthcare power of attorney wake up when you go to sleep, and when you wake up, they go to sleep. When you pass away, your living will passes away with you. That's when your last will and testament kicks in. So just remember, living will functions when you are alive. Last will kicks in after you pass away. For more personalized assistance, contact a knowledgeable estate planning attorney, like Griffith Exidius Law Group.